Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Last time I talked about a story where an officer was disciplined by being docked 8 days pay, which is not a whole lot of money for having testified without regard to accuracy or truth. Let's have a look at that case. So this is the case of the Queen and Andre Stevens out of the Ontario Court of Justice. So overview. On a summer night in 2018, a police officer in plain clothes was driving along Lawrence Avenue East in Scarborough when he saw a marked police cruiser about to turn off Lawrence onto Canlish Road, an area of recent serious gun crime. Now, I'm going to just mention here, the summer night in 2018 is actually more important than you might be thinking. We'll get to why. The officers thought the presence of the cruiser might stimulate activity in the immediate area. He was right. He saw a group of young men running away from Canlish onto Lawrence. As he slowed down, he saw two of the young men conduct what he believed to be a hand-to-hand drug transaction. One of them was Mr. Stevens. The officer contacted uniformed patrol officers and gave a description of the men. He then tracked them into the housing complex off Canlish. On the basis of what the officer said he saw, the uniformed officers caught up with Mr. Stevens and engaged him in an investigative detention. Investigative detention is not quite arrest, but you're also not free to go. They're holding you for a bit while they do a little bit more inquiry. According to one of the officers, when he told Mr. Stevens why they were detaining him, Mr. Stevens said that he only had weed and produced a bag of marijuana from his satchel. The officer then arrested Mr. Stevens for possession of marijuana. In the ensuing struggle, the officer felt the shape of a firearm in Mr. Stevens' satchel. When the satchel was searched, it was found to contain a loaded handgun, as well as marijuana, cocaine, and methamphetamine. So this is why it matters a lot that it was the summer of 2018, because if he just waited until the fall of 2018, that marijuana might have been legal. And it might have been that he was showing the officers something that was legal to possess. However, at this point, by producing that marijuana, he was essentially admitting to a crime and giving the officer much more power, because now the officer can arrest him and now the officer can search him. So if you're carrying a loaded handgun and cocaine and meth and, all sorts of other illegal drugs, letting the cop know, oh, hey, here's one of the illegal things I'm carrying, is a really bad strategy. It does not work out here for Mr. Stevens, although ultimately we'll see how this ends. Mr. Stevens is facing numerous gun and drug charges. His defense is exclusively charter-based. His primary submission is that his Section 9 rights were breached because the basis for his initial detention, the plainclothes officers claim to have seen the drug deal, is not supported by the evidence. The grounds for his detention were therefore non-existent and resulted in a violation of Section 9 of the Charter, both for his detention and his subsequent arrest. He says there was an accompanying breach of Section 8 in the search of his satchel incident to his arrest, and that his right to counsel under Section 10 was breached in a variety of ways upon his initial detention and his subsequent arrest, both at the scene and at the police station. So his Section 9 rights are his rights not to be detained or arrested without cause, and his Section 8 rights are similar rights with respect to searches. So essentially the argument here is that the officer should never have detained him, and that once that detention started, his Section 9 rights were breached, and that everything that follows that is itself a charter violation because it follows from that breach. There's also several allegations here with respect to breaches of his right to speak to lawyers. I'm not going to get into that too much. Those arguments are ultimately not fruitful here. In my view, Mr. Stevens has met his burden of making out the Section 8 and Section 9 violations. A careful examination of D.C. Reeves' testimony, assessed in the context of the CCTV evidence, demonstrates that his description of what he saw and did cannot be accurate and cannot be relied on. As a result, I find that D.C. Reeves did not have reasonable grounds to suspect that Mr. Stevens was involved in criminal activity, making Mr. Stevens' subsequent detention and arrest by P.C. McInnes arbitrary and unlawful. The search of Mr. Stevens' satchel was undertaken incident to an unlawful arrest and was a breach of his Section 8 rights. I am not satisfied that the defense has established that Mr. Stevens' right to counsel was breached. his spontaneous admission and production of marijuana happened before there was any opportunity to afford him his right to counsel. His rights were provided to him as soon as reasonably possible after his arrest, and duty counsel was facilitated within a reasonable time once at the police station, particularly in light of the unusual arrest situation occurring in the station at the time. I do not accept that there was a reasonable opportunity to implement the right to counsel at the roadside. While I accept that there may have been a breach in relation to recautioning Mr. Stevens of his increased jeopardy when his bag was searched in the booking hall, any such breach was negligible and, in any event, unconnected to the gathering of any evidence against Mr. Stevens. The breach of Mr. Stevens' Section 9 rights was serious and had a significant effect on his liberty interests. Notwithstanding the nature of the offenses with which he is being charged, in my view, the admission of the evidence found in Mr. Stevens' satchel would bring the administration of justice into disrepute, and it must be excluded. As a result, Mr. Stevens is found not guilty on all counts. So that's a very very broad summary of what's going on here. We're going to get into the details of the arguments and the details of what's going on in this case and why the judge comes to those conclusions. But if you only care about what happened, this is probably where you stop watching. Continuing on for the legal keeners among us. So, general legal principles. Mr. Stevens is, of course, presumed to be innocent. There is no burden on him to prove his innocence. That burden always rests with the Crown unless and until it proves his guilt beyond a reasonable doubt. This is a general sort of statement of law, but this always applies in criminal charges. You don't have to prove your innocence. The Crown has to prove your guilt. The judge continues on with, this is a particularly important principle to bear in mind where, in a case such as this one, the defense is based on a claim that the key evidence against Mr. Stevens should be excluded for a breach of his charter rights, and the trial proceeds as a blended voir dire. It is important to be alive to the differing burdens and apply the appropriate onus in disposing of both the charter application and the trial proper. So what this means here is that a blended voir dire means that it's being run at the same time as the trial. But that's not how these things necessarily have to run. In fact, the default for these is that the voir dire is its own separate mini trial. So you have a trial just on the charter issues, which is actually more properly a trial on the evidence and whether that evidence is itself admissible because of the charter breaches. And then if that evidence goes through, then you would have the rest of the trial at that point. But the reason why it makes sense sometimes to blend those two things is that you can have a trial on all of the issues at once, saving a lot of time. And of course, time is money when you're talking about courtroom time and lawyers and all sorts of other things. So that is a reason for a blended voir dire. They are much more appropriate with a judge because, of course, the judge can disabuse themselves. But the reason why the judge is making this comment here is because of the necessity to sometimes disabuse yourself if you're a judge, because in the blended voir dire, the judge hears the evidence that is at stake before they decide on whether or not to be excluded. So that becomes a bit of a potential thing in that could otherwise maybe skew the judge's thinking. So this is sort of the judge reminding themselves of important trial principles. That said, the parties agree that the outcome of this case turns exclusively on my findings with respect to Mr. Stevens' charter application. The elements of the offenses are otherwise admitted. For all practical purposes, therefore, the determination of the charter issues on a balance of probabilities will be determinative of guilt or innocence. So what they mean by this is that the parties have agreed that essentially, if the evidence is going in, that Mr. Stevens will be convicted. The defense has admitted that the elements of the offense are made out if the evidence goes in. However, if the evidence does not go in, particularly with respect to a firearm and the drugs, you can't convict for possessing a firearm and possessing drugs if the drugs and the gun are not allowed in. So that's basically the long and short of this. If the evidence goes in, conviction. If the evidence does not go in, acquittal. Arbitrary detention. Police may detain a person for investigative purposes if they have reasonable grounds to suspect that the person is connected to particular criminal activity and that such a detention is reasonably necessary in the circumstances. Reasonable grounds to suspect requires that the police have a suspicion that is grounded in objectively discernible facts, which could then be subjected to an exacting, independent judicial scrutiny, taking into account all of the circumstances. However, this is actually a fairly low standard. The police are allowed to make sort of brief detentions on fairly minimal grounds. Mr. Stevens' foundational claim is that his detention by PC McInnes was arbitrary because the information provided to PC McInnes by DC Reeves, and which PC McInnes relied on to justify the detention, was false. The defense also submits that even if DC Reeves saw what he said he saw, it would not amount to a reasonable suspicion that it was a drug transaction. Ms. Casey describes it as no more than a hunch, falling short of reasonable suspicion. The Crown disagrees and said that it clearly amounts to a reasonable suspicion that there had been a hand-to-hand drug deal. I do not understand the Crown to take issue with the proposition that if PC McInnes relied on false information provided by DC Reeves in detaining Mr. Stevens, then his subjective belief alone is insufficient to justify the detention. So what the court is indicating here, they're sort of laying out the defense position. The defense is saying that Reeves provided information to McInnes, and McInnes was relying on this probably in good faith, right? McInnes doesn't have any reason to suspect that this information is bad information. However, because it has to be objective facts that ground this, the fact that subjectively McInnes might be acting in good faith and relying on this information, if McInnes is being lied to, that additional step of Reeves communicating that false information to McInnes doesn't sort of launder that false information. So McInnes's information has to be truthful, what was passed along to him. As a preliminary issue, it is necessary to determine whether Mr. Stevens was detained before he voluntarily produced marijuana from his satchel leading to his arrest. The Crown concedes that DC Reeves was clear that he was intent on investigatively detaining Mr. Stevens right from the outset. But the Crown submits that Mr. Stevens is not actually detained until he stops walking away from the officers and they, as the Crown put it, gain control of the situation. In other words, Mr. Stevens' detention commenced after PC McInnes first called out to him, but before he pulled the marijuana out of his satchel. I agree with that assessment of the evidence. However, that assessment's probably not going to be super helpful because it's still before he produces the marijuana. Applying the 3 criteria for psychological detention outlined in Grant, I find that at the point Mr. Stevens stopped in response to PC McInnes' direction, he was detained. As the court put it in Subaru, the officer's conduct in the context of the encounter as a whole would cause a reasonable person in the same situation to conclude that he or she was not free to go, and that he or she had to comply with the officer's request. If an officer is telling you, stop, you're not allowed to leave yet, then you're probably detained. I do not accept the defense submission that if DC Reeves saw the so-called hand-to-hand transaction as he described it, that this would fall short of reasonable grounds to suspect that Mr. Stevens was involved in a drug deal. In my view, looking at all the circumstances, it would satisfy that low threshold. Now, I always sort of wonder about this because this is something that appears in a lot of case law, but I'm wondering if this is something that maybe the courts need to reevaluate, because if you go back, 15 years, there's probably not a whole lot of circumstances where people would meet on the street and engage in sort of a hand-to-hand passing of objects that wasn't suspicious. But I think that's becoming a little more common. And I think to a moment, if some time ago there was the eclipse was coming and lots of people wanted to watch this, and there was a big sort of thing about getting sort of eye protection so that you could see this safely. And somebody on online, I forget which service it was, but indicated basically that they had a bunch of welding visors that were the right strength and that they were selling them. And I thought, well, I'd like to get some. And I was lucky enough. This guy was just saying, I just want to share them for cost. So I went and met up with this guy, handed him cash, and got in, a small plastic or glass, I'm not actually sure which, square. And if you were watching this from a distance, you'd probably see two cars meeting in a parking lot and me exchanging cash for some sort of small object. Is that going to be enough to conclude that there's a drug deal going on? I suspect that there's actually a lot more of these kinds of hand-to-hand exchanges going on now in the era of Facebook Marketplace and Kijiji and all of these different services. So that's just kind of me contemplating, but I always sort of wonder about this because I've had some hand-to-hand transactions myself that were not at all drug-related. The heart of the defense position is that I should reject D.C. Reeves' evidence of what he saw because he was not a credible witness, and what he claims to have seen is logically and physically impossible in light of the CCTV evidence. I agree with that submission. And most people reading this aren't sort of feeling this in the same way that a lawyer is going to feel this, because that is an incredible bomb when you're talking about a police officer. Police officer not being found credible is a big deal. The courts are typically very reluctant to make that kind of finding. Mr. Stevens bears the burden of establishing a Section 9 breach on a balance of probabilities. Put in more concrete terms, he must persuade me that it is more likely than not that D.C. Reeves did not have a reasonable basis to conclude that Mr. Stevens had engaged in criminal conduct, and more particularly, that he did not see Mr. Stevens engage in a hand-to-hand drug transaction. The essence of D.C. Reeves' evidence was that he saw Mr. Stevens and 2 or 3 other men jog onto Lawrence Avenue, and that, from his scout car 150 feet away, and looking over his shoulder, he saw their various movements, which he concluded looked like a drug transaction. That's quite a long way away, and when you think about looking over your shoulder, you don't typically get a great view, particularly in a car. So that already is a bit of a long distance there. His credibility on this issue is central to the determination of the Section 9 claim. D.C. Reeves' credibility, in turn, depends on the likelihood that it was physically and logically possible for him to have seen what he said he saw and done what he said he did, the extent to which his version of events is undermined by other evidence, and his credibility as a witness generally. D.C. Reeves testified that after seeing the scout car turn from Lawrence Avenue onto Canlish Road, he saw Mr. Stevens and 2 or 3 other men jog down the pathway on the north side of Lawrence Avenue, just west of the church, onto the sidewalk. D.C. Reeves continued driving eastbound on Lawrence and noted that the men had kind of spread out because of the different paces that each person was jogging at. He testified that he saw a white male who was shorter than the other men with shorter blonde hair, who ran with the black males out of the complex once they hit the sidewalk, started walking. He then said, and now they're dropping into quotation, "I observed a male white, pulled out his cell phone. From my observations, I was slowly going down Lawrence. I was able to maintain view of these males on the sidewalk." So this is interjection, white male had pulled out his cell phone I'm not sure if he was talking on his cell phone, but it was very brief. And he began pacing back and forth on the sidewalk in front of the church where the other 2 males were walking a distance behind him, as to give the concept that they weren't with him, or he was unknown. At one point, the male white had turned around, seen the other 2 males on the sidewalk. I believe he knew they were there, but he had turned around, put his cell phone away, was looking around to see if everything was okay. I don't know why, but it feels kind of weird to describe it as male whites, or just that's a bit of a weird language thing, but it just feels kind of off. D.C. Reeves went on to describe seeing the men interact with each other. The white male put his cell phone in his pocket when he noticed the 2 male blacks that were on the sidewalk. You can see that when the judge is interjecting in sort of bracketed text, they swap over the words. Again, I don't think anything turns on it. It just feels kind of weird somehow. He approached, was looking around, as I said, as was the one male wearing the army camo pants or pattern print on his pants. He was also looking around, so was the other friend, just to make sure, in my view, just to make sure that the police were out of the area. So a handshake was made between the male white and the male black. So the male black was facing eastbound on the sidewalk. The male white was facing westbound on the sidewalk on the north side of Lawrence. A very short interaction had happened between the 2, and then another longer handshake was made after that. And then the male white had put with his right hand in his right pocket put his right hand into his right pocket, and then they'd split off in two different directions. It's always weird when you're reading transcript because transcript never comes out like you'd expect writing to. In our speech, we tend to have all sorts of starts and stops and ums and ahs that we just don't necessarily notice. But the instant you start reading yourself in a transcript, you just go, oh man, did I actually say that? Was I talking that poorly? So this is what D.C. Reeves said he believed to be a hand-to-hand drug transaction. It is this claim to have seen the hand-to-hand transaction that the defense challenges as incredible. It is contrary to common sense, Ms. Casey submits, that anyone driving on a busy thoroughfare such as Lawrence Avenue could observe over his shoulder 150 feet behind him the kind of conduct D.C. Reeves said he saw. And again, if you're in a car, and you're looking over your shoulder, you're limited to sort of seeing out the back windows, maybe a bit out the side windows. But if it's a busy thoroughfare, you're going to be trying to see this through other traffic, and that makes it even harder. And 150 feet is not a short distance. In addition, she submits, when one examines the timing of the movements of the three men and the location of D.C. Reeves' car in the CCTV, his claim not only becomes unlikely, it becomes impossible. I will explain why I agree with the latter submission. D.C. Reeves' evidence of seeing the hand-to-hand drug transaction is inextricably bound up with his very clear evidence of the sequence in which he made his observations. It is worth summarizing them again in the order in which he says they happened. Drives eastbound on Lawrence and sees a cruiser waiting to turn left onto Canlish, waits for the cruiser to turn, proceeds eastbound on Lawrence at approximately 40 kilometers an hour, sees Mr. Stevens and 2 or 3 other men jog down the pathway onto Lawrence east of Canlish and just west of the church, slows down drastically to see what they're doing, continues driving slowly eastbound on Lawrence, sees the white male pull out his cell phone. White male begins pacing back and forth on the sidewalk in front of the church with the other 2 males walking a distance behind him. White male turns around, puts his cell phone away and looks around. White male puts cell phone in his pocket. Mr. Stevens and the other black male are looking around. The white male, facing west, briefly shakes hands with Mr. Stevens. There's a second longer handshake between the 2 men. The white male puts his right hand in his right pocket. The white male walks off eastbound on Lawrence. Mr. Stevens and the other male go in the opposite direction. D.C. Reeves identified on an overhead map of the area precisely where he said the transaction took place and where he was when he saw it. He said that this was a distance of approximately 150 feet. He saw the men by turning and looking over his left shoulder. According to D.C. Reeves, there was traffic on eastbound Lawrence at that point, but there was little traffic immediately in front of him because he'd slowed up and stopped a little bit earlier when watching the scout car turn onto Canlish. D.C. Reeves testified that after seeing the transaction, he took the following actions. Turns into a plaza with a Pizza Nova restaurant on the north side of Lawrence Avenue and drives through the parking lot. Stops for a little bit and begins calling for other units to attend. Pulls back out onto Lawrence and drives westbound. Turns into the entrance on the east side of the church and circled through around that church, drove around the parking lot and came out the west entrance of the church and circled back eastbound on Lawrence. The movements of Mr. Stevens and the other men he was with are tracked via multiple CCTV cameras located throughout the housing complex on Canlish Road. The cameras do not capture the point on Lawrence Avenue where D.C. Reeves says he saw the suspected drug transaction. Camera 16, however, shows the movements of Mr. Stevens and 2 other men, including the so-called buyer, the white male with bleach blonde hair and green shirt, as they go from the pathway just off Lawrence Avenue onto Lawrence and begin to walk eastbound towards the point of the alleged transaction. Most of the clips, and in particular clip 16, are of extremely high quality, permitting a detailed analysis of the movements of the 3 men. A close review of relevant CCTV clips shows the following. I'm just going to stop and comment a little bit on CCTV because a lot of people go, oh, they got it on camera. This is going to be an open and shut case. But most closed circuit camera footage, a lot of it's really awful. A lot of it's really good at showing you what happens, but not so much who did it, because typically the resolution is really bad. But that's changing. More and more cameras these days are of much better quality. It used to be that you'd only really find really good cameras, for instance, in casinos, where you could read the brand of people's pants if you zoomed in on the footage. But now that's being found perhaps in some surprising places. So you can never really know if in disclosure they say we've got video footage. You can never really know. It might be really crystal clear. It might in fact be clearer than this video that you're watching right now. Or it might be terribly grainy and just completely unusable. Other than just sort of seeing broad things like how people are moving their hands. All right, carrying on. So clip 19, and they have timestamps here. So at 11:09, DC Reeves slows his car behind the marked cruiser as the cruiser waits to turn left on Canlish Road from Lawrence. 11:19, the cruiser turns onto Canlish. DC Reeves speeds up and continues eastbound on Lawrence. That's quite a time to be waiting for somebody to turn left. That must be a busy street. 11:23, DC Reeves' car is seen on Lawrence Avenue passing the path from which Mr. Stevens runs. The white male starts to stand up, and this is bolded. 11:28, Mr. Stevens enters the shot. He, the other black male, and the white male start jogging towards the sidewalk on Lawrence Avenue. 11:39, Mr. Stevens and the white male are both on the sidewalk heading east. They are walking, not running. Mr. Stevens is ahead of the white male. 11:59, Mr. Stevens goes out of camera shot. He is still walking. The white male is behind him. 12:04, the white male walks out of camera shot. 12:10, the second black male walks out of camera shot. 12:15, DC Reeves' car is seen entering the camera shot, driving south on the roadway towards Lawrence Avenue, immediately west of the church. And then 14:30, Mr. Stevens and the other black male walking westbound on Lawrence Avenue turn north to walk up the alleyway adjacent to the church and into the Canlish complex. This CCTV footage, viewed in conjunction with the annotated overhead photograph of the area that is Exhibit 3, provides independent evidence against which to measure the veracity of DC Reeves' claim as to what he saw and where he drove. It corroborates some aspects of DC Reeves' testimony. And this is not unusual. Even if somebody's evidence is bad, it's rare that somebody's evidence is completely manufactured. People blend things that happened with things that didn't. And that's true whether or not they're intentionally misleading or if they're just wrong. They're always going to get, or almost always going to get, some elements of the testimony that match existing facts, but there may be situations where they don't. So first, it can, and sorry, I'll just back up a little here. Often what people do is they'll point to things that are known accurate and saying, well, we know this person is truthful because, these three things conform to what's going on. But that never really makes a whole lot of sense to me because, of course, somebody who is telling, something that is either wrong or untruthful is going to have elements that still match up with actual facts. Nobody just comes in and makes up like wildly untrue things. Nobody's going to come in and say, oh, well, I rode there on my dragon, and then, yeah, it doesn't happen. So first, it confirms that he drove along Lawrence Avenue East at the time and place he said he did. Second, his location, as shown on the CCTV, is consistent with his evidence that he first noticed the men on the pathway leading out of the Canlish complex and saw them running just as the cruiser turned onto Canlish. Third, it corroborates DC Reeves' evidence that he saw 3 or 4 young men, 2 of whom were black and 1 white, on the north side of Lawrence Avenue in front of the church. Fourth, it supports his evidence that the 3 men walked east on Lawrence and then, after the transaction, split off in 2 different directions, with the white male walking eastbound on Lawrence towards Kennedy Road. At the same time, however, the CCTV highlights what in my view is an irreconcilable discrepancy between DC Reeves' version of events and what we know from the CCTV actually happened. Accepting, as everyone does, that the CCTV accurately depicts the times and places shown, and that the time elapsed on the CCTV is the actual elapsed time, it demonstrates that it was impossible for DC Reeves to have done what he said he did. I will explain why. DC Reeves testified that he saw the drug transaction the first time he drove eastbound, before turning around at the Pizza Nova and driving back westbound. He also said that the white male was ahead of the two black males just before the transaction, and that the white male was pacing back and forth on the sidewalk before the handshakes. Clip 16 shows that the white male behind Mr. Stevens when he walks out of shot at 12:04. The Crown submitted that the available window for the hand-to-hand transaction to have occurred was 1 minute, but that cannot be the case. The hand-to-hand could not have occurred before the white male walks out of the camera shot at 12:04 in clip 16. Otherwise, it would have been visible on the CCTV. DC Reeves' car appears driving south next to the church at 12:15. On DC Reeves' own evidence, he'd already seen the transaction by that time. Even if the handshakes happened immediately upon the white male going out of shot, an assumption which itself would be inconsistent with DC Reeves' evidence, DC Reeves would have to have seen it, turned into the Pizza Nova and turned around, stopped, turned back onto Lawrence Avenue, driven west for a couple of 100 feet, turned into the driveway at the east end of the church, driven up the east side of the church, circled through the parking lot, and appeared back in clip 16, driving south towards Lawrence Avenue, all between 12:04 and 12:15, a period of 11 seconds. On any common sense assessment of the evidence, this is not only implausible, it is impossible. So, that's quite the drive for 11 seconds. That would have to be quite the lead foot. DC Reeves was not equivocal or uncertain about what he saw. He was adamant that he'd seen the hand-to-hand and was clear in describing his movements after doing so. He gave an estimated measurement of how far away he was and readily marked his position and described his movements in relation to the map. If the transaction happened, it did not happen in the way he described. There is no version of events in evidence before me which could allow for DC Reeves seeing the apparent drug transaction and for the movements he said he made. I cannot reconcile DC Reeves' evidence with the objective and reliable evidence in clip 16. His appearance driving south at 12:15 makes it impossible for him to have seen a drug transaction on the north side of Lawrence Avenue from his stated position 150 feet east of it, stop, turn around, and drive through the church parking lot, all within a maximum of 11 seconds. So those timestamps earlier were not hour-minute, they were minute-seconds, it appears. I cannot rely on or accept DC Reeves' evidence. Absent speculation or unsupported assumptions about how he might have been mistaken, I am compelled to reject his claim to have seen a drug transaction. Ms. Casey also urged me to view DC Reeves' evidence in a negative light because of his failure to apprehend the white male when he had an obvious opportunity to do so. DC Reeves testified that there was only one white male involved in the transaction. He agreed that it was the male with shorter blonde hair seen sitting down at 11:23 in CCTV clip 16. DC Reeves repeatedly described the white male as the buyer or the takeaway, one half of the drug transaction. He also testified that he did not have grounds to arrest Mr. Stevens because he didn't have the takeaway, being what I deemed the buyer, so I didn't have the white male under arrest to see that he in fact had drugs on him. So I couldn't prove at that time that there was a drug transaction that had taken place. Because, of course, if the guy who is supposedly the buyer in a drug transaction doesn't actually turn out to have any drugs, you've got a real weak claim that this is a drug buy. Under cross-examination, DC Reeves testified that he was never able to identify the white male because he was gone, and he never saw him again. He agreed with the suggestion that the white male was very recognizable in his appearance, and that it would have been preferable to have arrested the buyer in order to establish the drug transaction. He would have at least stopped him if he came into contact with him again. In the context of this body of evidence about the white male, DC Reeves was confronted with CCTV clip 11, starting at 32:10. In it, DC Reeves is shown walking around the parking lot behind the church, where his car has been parked after Mr. Stevens was arrested. He's on the phone. It is a bright, sunny evening. The white male whom DC Reeves had described as the buyer, appearing exactly as he appeared when DC Reeves saw him make the apparent drug deal, walks through the parking lot from east to west, directly in front of DC Reeves. So, DC Reeves is on the case here. He's got this down, and this guy just breezes right past him. So DC Reeves testified that he did not notice the white male in the parking lot because he was on the phone at the time. Had he noticed him, he said, he would have done something because it would have just added more evidence to this case. He disagreed with the suggestion that he was not concerned about the buyer because his sole focus throughout was getting into Mr. Stevens' satchel. So the defense is suggesting essentially that they really wanted to have a look in that bag and that they didn't really care about the buyer or any of those details. It is curious that D.C. Reeves did not apprehend the white male. It is even more curious that he did not notice him. His ostensible powers of observation that evening as a trained police officer were otherwise apparently very sound. Can you hear a little bit of snark here? I can hear a little bit of snark here. A readily identifiable man he had suspected of being one half of a criminal transaction less than 30 minutes earlier walked directly in his line of vision, yet he did not stop him, follow him, or even call out for assistance in apprehending him. And keep in mind, this is the officer who says that he saw a transaction over his shoulder at 150 feet away through traffic. So super observant 1 minute, his ostensible powers of observation have somehow faded out at this point. Now, a phone can be distracting, but still, officers are theoretically at least trained to have some situational awareness because, we're told that the job of being a police officer is dangerous, that there might be people who... So you'd want to pay some attention. That said, the CCTV does show D.C. Reeves seemingly preoccupied with being on the phone, and it must be recalled that he had just been involved in the violent apprehension of a man armed with a loaded handgun. I take Ms. Casey's point that if he had indeed not seen a drug transaction, as I've been compelled to conclude, then he had an obvious reason to ignore the white male. Given my findings respecting the feasibility of P.C. Reeves' observations, I need not come to a conclusion about the impact of his failing to apprehend the white male. I will only say that while it does not particularly assist the Crown, it is not, standing alone, dispositive on the issue of the officer's credibility. So it's a small strike against the officer's credibility, but the officer's credibility is already kind of blown out of the water by the video evidence. Finally, Ms. Casey submits that D.C. Reeves' credibility is also eroded by the manner in which he gave his evidence. So this is demeanor evidence, how he was in court. I agree that he was at times evasive, non-responsive, unnecessarily combative, and keen to explain rather than answer the question asked of him, occasionally giving the impression of wanting to outwit defense counsel. Again, D.C. Reeves' testimonial style was not something which, standing alone, would cause me to reject his evidence, but it is one factor I have considered in assessing the veracity of his claim to having seen a drug transaction. In sum, I find that the defense has established on a balance of probabilities that D.C. Reeves did not have a basis to reasonably suspect that Mr. Stevens was involved in criminal activity. The grounds for detention he provided to P.C. McInnes were without foundation, and while P.C. McInnes had the necessary subjectively reasonable grounds to detain Mr. Stevens, those grounds were, seen in the light of all the evidence, objectively unreasonable. And again, that's because subjectively, P.C. McInnes has been told things that, would be reasonable for him to detain on the basis of. But those things were not true, and that therefore it was an unreasonable arrest, and so it was a detention of the Section 9 rights. The other thing I just want to point out here is that there are various aspects to D.C. Reeves' testimony and to the other sort of small contradictions there. And the court has basically said, the court says that they would not reject D.C. Reeves' evidence on those points. So, but for the CCTV here, it's likely that they would never have discovered that this was not an accurate retelling of events. I have to commend defense counsel here. It looks like defense counsel did a hell of a job in terms of going through the timing and figuring out exactly where things had to be. That's impressive. That's some really good defense work. But still, but for that CCTV footage, D.C. Reeves might well have been believed. So that is something to be sort of concerned about in the sense of the court system. It shows the vulnerability of the court system to false evidence, particularly from police officers. Section 8. The firearm and the drugs were found in Mr. Stevens' satchel when it was being searched incident to his arrest. The arrest flowed directly from Mr. Stevens being unlawfully detained by P.C. McInnes. There's no suggestion that the arrest could be meaningfully hived off from the initial detention from a Section 9 perspective. A search incident to arrest is only justified if the underlying arrest is lawful. And a search incident to arrest is that when you're arrested, the police are allowed to search you for various things. They're allowed to check you for instance, means of escape from custody, as well as weapons and other things that you shouldn't have while in custody, but they're also allowed to check you for evidence that in some way meaningfully connects. So they're allowed to do a lot of searching incident to arrest. There's limits on that, but that's sort of beyond the scope of this video. However, the search incident to arrest would be incident to the arrest, which happens only after he produces the drugs. So Mr. Stevens was arrested because he voluntarily produced marijuana from his satchel, but he did so only after being unlawfully detained. In my view, the arrest is so closely connected to the detention that it is irreparably tainted by the lack of a lawful basis for detaining Mr. Stevens in the first place. Absent that unlawful detention, the arrest would never have materialized. He wasn't about to just produce the drugs just for giggles. He does it because he's trying to talk his way out of this interaction with the police. What have I said about trying to talk your way out of an interaction with the police? It is dumb. Very few people, I can't say nobody, but very few people successfully talk their way out of an interaction with police, but lots of people successfully shut their mouth out of an interaction with police. So Mr. Stevens made a very serious blunder in terms of producing that marijuana, but ultimately it doesn't go anywhere here. The seizure of the contents of Mr. Stevens' satchel was not incident to a lawful arrest. It was therefore a breach of Mr. Stevens' Section 8 right to be free from unreasonable search or seizure. So you can see these sort of cascade of rights violations here. Because the detention was unlawful, then the arrest was unlawful, and therefore the seizure of the contents of his bag was also unlawful. I'm going to skip over the right to counsel stuff. There were some arguments about whether he should have been afforded a right to speak to his lawyer sooner than he was. Ultimately, the court sort of makes some suggestion that there might be a rights violation, but that it's only trivial or inconsequential, and ultimately rejects any violation of Mr. Stevens' right to counsel. So we don't need to go over that for the purposes of this video. If people are interested, I could do another one more heavily on a more particular rights to counsel kind of case. Section 24.2. I found that, and 24.2, just so that you understand where we're going, is now that they've found that there are rights violations, 24.2 is the step of determining whether or not those violations are serious enough that they outweigh society's interests in terms of hearing the case with all of the evidence in order to exclude that evidence. So 24.2 is a further test to determine if evidence that was obtained in violation of a charter right should be excluded from the trial. I found that Mr. Stevens' Section 8 and Section 9 rights were violated in the course of his detention and arrest. It is Mr. Stevens' burden to demonstrate on a balance of probabilities that the firearm and drugs that were found in his satchel were obtained in a manner that infringed his rights, and, if they were that, having regard to all of the circumstances, the admission of them into evidence at his trial would bring the administration of justice into disrepute. In my view, the firearm and drugs were obtained as a direct result of Mr. Stevens' arbitrary detention and subsequent arrest. I've already concluded that Mr. Stevens was detained when he responded to P.C. McInnes calling out to him to stop. Without the faulty information from D.C. Reeves, P.C. McInnes would have had no reason to demand that Mr. Stevens stop and talk to him, and he would not have been arrested. I accept that Mr. Stevens' arrest was initially premised on him voluntarily producing the marijuana, but that flowed inexorably from his unlawful detention. In my view, it would be unfair and unrealistic to suggest that, having been arbitrarily detained, Mr. Stevens' subsequent decision to volunteer his possession of marijuana somehow cures the breach that was manifest by the initial detention. So essentially, the judge rejects this notion that the detention becomes lawful once the drugs are produced, because that would essentially say that the initial reason why they had to detain him gets wiped away by him doing this, notwithstanding that that decision was made because of that initial detention. So I can see where the judge is going. I agree with the judge's decision here. I think that it would have been a very dangerous thing to rule the other way here. It would have very much undermined the entire charter inquiry here. And I think this is a really great illustration of why charter rights are important, because frankly, the remedy here, Mr. Stevens is enjoying the remedy, but society also enjoys a remedy when behavior like this is curtailed. So let's continue on. The well-known Grant inquiry calls on a trial judge to determine the admissibility of charter-tainted evidence with reference to 3 factors. The courts love 3-part tests. I'm not sure why, but 3 seems to be the magic number for how many parts a test should have. Yeah, it's a weird thing, but oh well. The seriousness of the charter infringing conduct, the impact of the breach on the charter protected interests of the accused, and society's interest in a trial on the merits. In the Queen and Lay, or Lee, I'm not sure necessarily on pronunciation, Justice Brown recently explained the focus of the 24-2 analysis in these terms. Where the state seeks to benefit from the evidentiary fruits of charter offending conduct, our focus must be directed not to the impact of state misconduct upon the criminal trial, but upon the administration of justice. So this is upon society at large. Courts must also bear in mind that the fact of a charter breach signifies in and of itself injustice and a consequent diminishment of the administration of justice. What courts are mandated by Section 24.2 to consider is whether the admission of evidence risks doing further damage by diminishing the reputation of the administration of justice, such that, for example, reasonable members of Canadian society might wonder whether courts take individual rights and freedoms from police misconduct seriously. We endorse this court's caution in Grant at paragraph 68 that while the exclusion of evidence may provoke immediate criticism, our focus is on the overall repute of the justice system viewed in the long term by a reasonable person, informed of all relevant circumstances and of the importance of charter rights. This is a really heavy paragraph, as is kind of the norm for Supreme Court decisions. So they're saying that when they say a reasonable person informed of all relevant circumstances, they're kind of saying not necessarily the news media or people who are just getting their information from the media, because the media likes to make things, they like to frame things in a way that makes you angry and that tends to get more interest. Often I see cases where if they went and explained a little bit more about why something is happening or what's happening, people would be less upset by it and thus less likely to click a headline and, see the ads and get the dollars. I mean, I understand that. I'm also kind of in the business at this point of getting eyeballs on videos, but I want to get eyeballs on videos by explaining things and not by shading them in one way or another. But that's just kind of the nature of the world. So they talk about the reputation of the administration of justice and consider what would happen if particular behaviors were allowed to become normalized. You have a right not to have the police kick down your door and search your house just because they feel like it, or just because they've got a hunch, or maybe just because they've heard a rumor around town that you are doing bad things. They need to have better evidence than that. And we rely on these freedoms in terms of our day-to-day. They're essential for our sense of well-being. I think that if the police were kicking down doors, sort of going, for instance, if there was a notion of a gun in a neighborhood and they went door to door searching everyone's house looking for this gun, I think that the Canadian public would feel less secure from the police than they might have felt over that gun, for example. So it's very important, and there's always a tension in society. One thing I hear people say is, well, why shouldn't we just leave the evidence in and then we can punish the officer outside of that? Well, as I commented, punishing the officer tends to be fairly ineffective. If you watch the previous video, it's not clear. I did some back of the napkin math and I screwed it up. The amount of that they docked him is unclear, but it's certainly less than $5,000. And the problem is that if we just end up with these low penalties, it just becomes a price of doing business. The one thing that really does tend to shape police conduct is when they lose cases, because that's actually where they may see some more serious consequences, is if they keep losing cases because they can't follow the charter rules. Eventually that will get them in more trouble than our system for punishment actually seems to manage. So the seriousness of charter infringing state conduct. This factor contemplates a spectrum of conduct from inadvertent and minor to willful or reckless disregard of charter rights, taking into account any extenuating circumstances. The more severe or deliberate the state conduct, the more it will be necessary for a court to dissociate itself from that conduct by excluding evidence connected to the breach. An intentional or flagrant breach will inevitably have a negative effect on the public confidence in the rule of law and risk bringing the administration of justice into disrepute. So intention matters a lot here. Let's say, for example, that the police are going and they're searching a house because they have a search warrant. And let's say that somehow in the fax machine there was a smudge, and what was supposed to be a 6 ends up getting turned into an 8. So they go to the wrong house and they raid the wrong house, but everybody believed that they were at the right house. That might be severe in terms of the impact on the people being searched, because a house search is a big deal. But in terms of the intentionality, it might be, okay, that was an honest mistake brought about by, a weird circumstance. Whereas, let's say it's 916, Sycamore Street or whatever, street, and they search 916 Sycamore Street, and then they say, nothing here. You know what? We're already in the neighborhood. Let's just go next door and search 918 Sycamore Street. And there they find something. That would be an intentional breach and much more serious. The court has very little regard for intentional breaches. I have found that D.C. Reeves testified to a course of conduct on his part that simply could not have happened. On the officer's own evidence, his claim to have seen a drug transaction at the time and place he said he did is simply not sustainable. This is a troubling and serious finding to have to make. It amounts to a finding that D.C. Reeves testified under oath to something that could not have happened, something which caused the detention and arrest of Mr. Stevens without reasonable cause. This is severe state misconduct from which courts must dissociate themselves by excluding evidence linked to that conduct. While a good faith breach reduces the need for a court to dissociate itself from the charter infringing state conduct, I see no version of events on the evidence before me which would permit a conclusion that D.C. Reeves acted in good faith. It is the opposite. This factor pulls irresistibly in favor of exclusion of the evidence. Now, I want you to listen, think about what you've heard so far and listen as you go on, because there's some words you're not going to hear. You're not going to hear lied. You're not going to hear perjury. You're not going to hear any of these things. That's a step beyond what the court finds. The court finds simply that he provided testimony that is impossible and not sustainable. Now, I don't know if the judge was thinking that D.C. Reeves lied intentionally. I can't know that. I cannot put myself, I don't have mind reading powers. But courts tend to be very reluctant to make that sort of finding with respect to police officers. And part of the reason is that a finding of intentional misleading would end that officer's career. But sometimes maybe a career should end. That's kind of my feeling here. And where we have this situation where the evidence is simply not possible and is only detected because of this video, it's concerning, to say the least. The impact on Mr. Stevens' charter-protected interests. This branch of the test asks a court to evaluate the extent to which the breach undermines the interests protected by the right infringed. It again contemplates a spectrum of impacts from the fleeting or technical to the profoundly intrusive. It requires a two-stage analysis which first identifies the interests engaged and then examines the degree to which the violation impacted on those interests. There's an obvious causal link between Mr. Stevens' arbitrary detention and his loss of liberty. It led to his arrest and his being brought into custody. Without the detention, Mr. Stevens would have been free to continue on his way, untroubled by the police. I find that the impact of the conduct on Mr. Stevens' charter-protected interests is significant, which on balance favors the exclusion of the evidence. And quite frankly, I think it's significant even at the point where he's going to walk away and the officer says, no, you stop, you come back. Because at that point, he's being restrained from what he would otherwise do, which is to leave, which is, quite frankly, a perfectly sensible thing. If an officer wants to talk to you and you don't have a reason to talk to them, or you don't want to talk to them, and you're not required to stay, leaving is a great move. So, yeah. Society's interest in a trial on the merits. This branch turns on an assessment of whether the truth-seeking function of the criminal trial process would be better served by admission of the evidence or by its exclusion. This in turn depends on the reliability of the evidence, the importance of the evidence to the prosecution's case, and the seriousness of the offense, said to have potential to cut both ways. So I'll explain a little bit on what they mean by that. The reliability of the evidence, we can imagine that evidence is along a spectrum of reliability. The handgun found in Mr. Stewart's satchel, or Mr. Stevens' satchel rather, is going to be very reliable. The officer's conduct didn't magic that handgun into being. It's not, this isn't a situation, for instance, of, a planted handgun or something. That handgun is a handgun. But if you think, for instance, of somebody who was brought into a police station and beaten with a rubber hose until they provide a confession, the reliability of that confession might be pretty poor. It might be that they're confessing because they did it, or it might be that they're confessing just so that they stop getting hit with the rubber hose. That's, you can see how the reliability itself may be undermined by the charter violation. The importance of the evidence to the prosecution's case. Some evidence might be of only tangential importance. The handgun in this case is of critical importance to the Crown proving that there was a handgun, obviously. But let's say, for example, that they instead of finding a handgun, let's say they found a receipt. And that receipt isn't for, you have purchased a handgun, but is maybe for, you went to this hydroponics shop that is known to sell hydroponic supplies. That might be evidence to suggest something, but it may not be sort of super strong evidence. So it might be of less importance to the Crown's case. Seriousness of the offense. The reason why they say that this has potential to cut both ways is that where the offense is really serious, society tends to want to have the case heard, right? We want to get to the bottom of it. We want to not exclude evidence and have people get off on technicalities, which is a major peeve of mine. I hate that term, but I still will use it here. But similarly, where it's a serious offense, we expect the police to spend more time and to be more careful than they might over, say, a shoplifting, because somebody is going to be facing a lot more jail time. It's a little more concerning if the police are violating your rights and, say, forcing a confession on a murder charge where you might be in jail for the rest of your life than it is if they're forcing a confession on a mischief charge where you're looking at a small fine. You can see that sort of element. Seriousness of the offense, therefore, is one of those things that really comes down to how you argue it, and I think it's not a great factor. I actually would have preferred if the Supreme Court had just said seriousness of the offense is not to be considered. I think might have been a better approach. But I'm not on the Supreme Court, so that's not the kind of call I get to make. Both the firearm and the drugs are, of course, highly reliable evidence. The exclusion of reliable evidence will tend to bring the administration of justice into disrepute. Moreover, reasonable, well-informed people may well lose confidence in the rule of law if a handgun is excluded because of a breach of Mr. Stevens' protection from arbitrary detention, particularly where, as here, excluding the firearm and the drugs will inevitably mean that the Crown's case cannot succeed. The exclusion of reliable evidence that effectively guts the prosecution of justice will have a more negative impact on public confidence in the administration of justice. So we've got sort of two factors that lean towards exclusion and one factor that leans towards inclusion. And now the court has to kind of mix them all in a barrel and stir it up and see what floats to the top. So balancing the grant factors. The first branch of the grant test strongly favors the exclusion of the evidence. I have found that D.C. Reeves conveyed a false or inaccurate basis upon which P.C. McInnes detained and then arrested Mr. Stevens. Detaining a citizen on the basis of an event which either did not happen or about which an officer gives false or misleading evidence at trial falls towards the most serious end of the spectrum of state misconduct. This is not a case where D.C. Reeves' evidence can be explained or rationalized as mere forgetfulness or mistake. The version of events he testified to at trial simply could not have happened. D.C. Reeves did not cast his evidence in terms of possibilities or uncertainties about what he did. I am compelled to conclude that D.C. Reeves testified with little regard for truth or accuracy, and that he likely provided false information which resulted in Mr. Stevens' detention. Again, that sounds like it's coming really close to outright saying that D.C. Reeves lied, but it doesn't actually get there. It gets so close, so very close. And you wonder if maybe just taking that little step further might have been the right call here. But again, I'm not in the judge's shoes. I don't know what the judge's position is here. And the judge may also not have wanted to go that further step because an appeals court might have been inclined to reverse on that basis, just because the courts are tremendously lenient on police officers. I've seen, personally cases where the officer had testified to something that was simply not what was seen on video. And the judge describes this as misremembering, or, while there were some inconsistencies between the officer's testimony and the other facts. And it's frustrating, but it's one of the things you just kind of have to live with, because getting that final further decision is a little, sometimes it's basically impossible, it feels like. The second branch of the grant test also favors the exclusion of the evidence. There was a significant impact on Mr. Stevens' liberty interests. The third branch of the grant test favors the admission of the evidence. The evidence is reliable and crucial to the Crown's case involving a drug dealer armed with a loaded handgun in a residential neighborhood plagued by gun violence. The threat to public safety represented by such individuals heightens the public interest in the adjudication of firearms cases on their merits. And I'd agree with that. I mean, this is somebody that society really wants to deal with. This is not somebody who, was transporting their handgun to the range and screwed up and left a cartridge in it, or somebody who was transporting their firearm to the range and didn't realize that their license had expired. This is somebody who's involved in bad stuff. I very highly doubt that there was ever a license issued to this particular individual. Bad stuff is going on here, essentially. Trial courts have struggled with trying to reconcile the Supreme Court of Canada's holdings under 24-2 in Omar and Lee. In that regard, I adopt the analysis of Davies in Miller. Brown J's ruling in Omar about the inherent dangers associated with guns, as endorsed by the Supreme Court, might suggest that cases involving the discovery of firearms in violation of the Charter are precisely the sort of cases that call for the admission of the evidence, even if the first two branches of the grant test favor exclusion. However, the fact that the evidence obtained in violation of the defendant's charter rights is a firearm cannot tip the balance in favor of admission in every case. That would be tantamount to creating a firearms exception under 24-2, which was rejected in Omar. Can you imagine this, where your charter rights just go away if you're accused of committing some sort of firearm crime? Because as a firearm owner, just about every way you can screw up with firearms is a criminal offense. So I'm really glad that they're still saying that I get to have charter rights, notwithstanding the fact that I'm a gun owner. I appreciate this, court. In fact, the Supreme Court reiterated in the Queen and Lee, a case decided 1 week after Omar, in which the court overturned the trial judge's decision and excluded a firearm, the disrepute may result from the admission of real, reliable evidence in circumstances that would amount to judicial acceptance of unacceptable conduct by the police. The Supreme Court noted that great care is required to resist creating special rules under 24(2) for certain types of cases. In that case, they were concerned about creating different rules for individuals who are seen to be dangerous, or for neighborhoods that are thought to have higher crime rates. The majority expressly rejected the idea that evidence obtained in violation of the Charter should be admitted in order to avoid the consequences of excluding it, which would be to return a dangerous person to the community. In other words, the court held that the effect of excluding important evidence, even a firearm, cannot overwhelm the analysis under 24(2). The court noted the requiring the police to comply with the Charter in all neighborhoods and to respect the rights of all people upholds the rule of law, promotes public confidence in the police, and provides safer communities. The same analysis must also apply in relation to the nature of the police investigation, requiring the police to comply with the Charter in all investigations, no matter what the type of evidence is involved, and to respect the rights of all people, no matter the nature of the alleged offenses, upholds the rule of law and promotes public confidence in the administration of justice. And can you imagine if they'd gone the other way on that? That would have been terrible. To say that your charter rights are diminished because you live in a bad neighborhood, you're a law-abiding citizen, but your neighbors get up to all sorts of things and therefore you get less charter rights. I don't buy into that, especially because that would have systematically targeted poor neighborhoods, and I have some issues with that. So I'm glad that the court has said that, you cannot basically short circuit the seriousness of the charter violation, for example. Continuing on. In my view, it would be detrimental to the long-term interests of the administration of justice to excuse the conduct of D.C. Reeves in this case. This is a difficult decision to make. I've presided in Scarborough for the last 8 years. I've seen the tragic results of drug dealing and firearms and the turmoil it creates in communities of good people and in families who lose loved ones at all too young an age. I have seen the danger that frontline police officers face every day in tackling gun crime and in answering the call to try and keep communities safe from the cowardice that gun crime represents. Those responsible for endangering our community must pay a heavy price. At the same time, those who protect our community bear a heavy responsibility, which includes being scrupulously candid with other officers and when testifying under oath. It means that even where they have a hunch that someone is up to no good, their instincts must be backed up by objective and truthful evidence of misconduct in order to justify interfering in the rights of all citizens to be free from arbitrary state interference. Again, you see, truth is mentioned a whole lot of times in its absence, but they don't go so far as to use the opposite word. Excluding the evidence in this case does not signal in any sense the court's approval of or sympathy with individuals who threaten their own neighborhoods by walking around with loaded firearms. Rather, the evidence is excluded to distance the court from the police conduct revealed in this case. On behalf of the Crown, Mr. Snow submits that I should consider bifurcating the evidence in the Section 24(2) analysis, excluding the drugs but not the firearm. I am not persuaded that there is a principled reason to conclude that a different result should obtain for the firearm than for the drugs. I find that balancing the grant factors favors exclusion of both the firearm and the drugs in order to maintain confidence in the administration of justice. Conclusion. Mr. Stevens' right to be free from arbitrary detention was violated. His arbitrary detention is inextricably connected to his subsequent arrest and the search of his satchel. The gun and drugs were obtained in a manner that infringed Mr. Stevens' Section 8 and Section 9 charter rights. In my view, their admission into evidence at this trial would bring the administration of justice into disrepute. The Section 9 and Section 8 application is granted, and the firearm and drugs are excluded from the evidence at this trial. The parties agree that, as Ms. Casey puts it, this is a charter or nothing case. Without the gun and the drugs, the Crown cannot prove any of the charges against Mr. Stevens beyond a reasonable doubt. Because how do you prove a gun with no gun? With respect to information 1815, you don't need the number, alleging 4 drug-related offenses, the Crown withdrew 1 count at the outset of the trial. Mr. Stevens is found not guilty on counts 2, as amended, 3, and 4. With respect to information number alleging 5 firearm-related offenses. Mr. Stevens is found not guilty on all counts. Now, I'll just point out here, whenever you see in the news, so-and-so was charged with 6 gun charges or 10 gun charges, I will note they found 1 handgun, and he was charged with 5 firearm-related offenses. And that is because firearms are so heavily regulated that there are a ton of overlapping charges, and police tend to charge all of them to see if they can get a conviction on any of them. So 1 gun, 5 charges, and he was found not guilty on all counts. I'm very appreciative of the exemplary skill and professionalism demonstrated by both counsel in their conduct of this trial and in facilitating the remote delivery of this judgment at a time when the administration of justice is laboring under unprecedented constraints. So one thing I'll say in comment, and this is kind of circling back to a point I made earlier, is the judge was pretty clear that it wasn't the officer's demeanor that caused them to reject the officer's evidence, and it wasn't some of the other inconsistencies or places where the officer's evidence didn't make sense. It was that it was contradicted by a video. And this video, which I will commend defense counsel here. Defense counsel clearly put a lot of time and effort going through this in a very meticulous way in order to establish that the detective's story was impossible. That's a tough task, and that would have required a lot of sitting there with the video and probably a pen and paper and just figuring this out. So, defense counsel did a heck of a job here, but for that, the officer's evidence would have been likely accepted, and this individual would likely have been convicted. So we don't know the scope of the problem in terms of how many police officers might be testifying to things that never happened and are just also never detected, which is part of why, if I circle back to the previous video, when we see that there was a fine or a 8 days docked pay, and depending on calculations, and there's some elements that we just don't know, that appears to be somewhere in the range of $1,500 to maybe $3,500 total lost cash, but that's all again before tax income, so it's not quite the equivalent of if you pay a fine with your after-tax income. So is that penalty enough? Is that enough to satisfy us? When we see here when the court says we have to harshly condemn this, certainly the accused in this file had a lot more at stake than the officer did. The officer, from what it appears, is continuing to be a police officer, and I am certainly glad that I'm not anywhere near this particular police officer. Perhaps especially if they watch my video, but regardless, this is not the kind of behavior we want from police officers, because you might say, well, yeah, this guy might be a really bad dude and we really don't like this guy, but it could happen to you. You might be seen by the police officer and the officer might decide that you look like a bad dude, or so we're all at risk from this kind of behavior, and I don't want to see it. I want to see the courts clamping down on it as much as possible. I think as much as we might condemn Mr. Stevens on this file, we also have to say it's probably a good thing that he's acquitted here, because that is the strongest real prevention measure we have for charter violations in our society. Anyway, you may or may not agree with me on this one. I know that charter rights are a very contentious topic, but let me know in the comments below. There's all sorts of things I want to get to in the next little bit here. Please like this video. Please share it with your friends. Subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: Sir Daniel Wicks of Alberta, Jason Elliott, D. Moe, Canada National Firearms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, and the CSSA, as well as at the $20 level, Dale Nesbitt, Cameron Johnson, and Andrew Elsich, and Sights and Arms Limited at the $30 level, as well as a number of you at the $10 level who will be in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge.